Kia ora, and welcome to this information session with Platinum Partners, Gibson Sheat Lawyers and Silver Partner McKone Consultancy. It's great to have you with us today. Today we'll be discussing a subject that I guess has come up over the last couple of years, but has really taken prominence since around December 22 when the law was enacted, and that being the fair pay agreements that were enacted into law in December 2022. And today we've got our two experts who will be here to talk about how the fair pay agreements will affect your business. I'm Patrick McKibbin, and I'm the CEO at the Hutt Valley Chamber of Commerce. And as a chamber working across the Hutt Valley, we're extremely lucky to have some absolutely fantastic partners, and two of the people from those organisations are with us today, experts in their field. So big welcome to Michael O'Flaherty from Gibson Sheat Lawyers. Michael's a senior associate working in the Wellington Commercial Team, and he specialises in employment law and property law, as well as employment-related immigration matters. So great to have you here, Michael. Thanks for giving up your time today. We've also got Tony McKone. Now, Tony, I've known for a little while longer than Michael. He's a board member here at the Chamber and has been associated with the business community, both here in the Hutt Valley, but across the Wellington region and across New Zealand, in fact, for a number of years. Tony is a director and principal advisor for McKone Consultancy, and they are an employee and employment relations specialist company that proudly works with small to medium-sized businesses in a strong collaborative partnership, offering high-value thinking and processes to help clients deliver on their investments and support their people. So Michael will talk through us the basics of the fair pay agreements, providing you with information and providing you with insight into what they are and how they might affect you. And then we'll move on to some questions with Tony and Michael that businesses have sent us to specifically get answers to. So hopefully you'll enjoy this. So if you have any further questions at the end of this video, and I'll repeat this towards the end, please don't hesitate to contact me or the Chamber of Commerce, and we can connect you up with Michael and Tony to answer those specific questions. But thank you for watching today, and we hope that you will find this really useful. So I'm going to hand over to Michael now. Thank you very much.
Great, thanks, Patrick. So I've just got a presentation to talk through. So we'll just discuss basically what the Act is and what it's going to mean for for the businesses out there. So a bit of an overview of what we'll slightly touch on here. So there's the background of the Act, overview of how the Act came to be, a bit of the information around how the process works, so how it's initiated, who's involved, what the timeframes are, what issues we foresee may arise, and then for the employers and employees out there, what their rights and responsibilities are, and then a little discussion around penalties before we get into that Q&A. So just a bit of brief background. So this was a bill that was introduced back in April 2022, although there was a lot of discussion about that prior to that date, and it became law on the 1st of December 2022 after it was voted in November. The legislation sets out that its main purpose is to improve employment terms for employees by providing a path for bargaining for minimum standards over specific industries or occupations. And so essentially the goal was to mitigate the risk of exploitation across industries. So obviously there'll be some employees that are already covered by collective bargaining, and other employees that will be on their individual employment agreements. These fair pay agreements sit on top of all of those and provide the basis for negotiating those minimum terms and entitlements. The agreements can be based on occupational industry, and we'll get into what the current ones proposed are and what they look like. And it does override, the fair pay agreements will override the existing obligations in the individual employment agreements as well as those collective agreements. And there's a bit of uncertainty, obviously, around the future of fair pay agreements, as the National Party at the stage has given an indication that they would look to repeal the legislation if they were elected into government. So it's a bit uncertain the future of them at the moment, but we mean to operate as though it's going to continue. So let's get into it. So in terms of the Fair Pay Agreements Act at this stage, what is it? So you can find a lot of information on the Employment New Zealand website. There's a very helpful guide that sets out how it's initiated, how the bargaining process works. And there's also an MBIE dashboard there that's got some information on the current applications that are there. So I've just put the 4 that have currently been applied for and accepted for processing, and those are the hospitality related general, and then 1 for supermarket and groceries, and then 2 for the interurban, rural and urban bus transport. Just briefly on the hospitality one, so this was based on the fact that 1,000 employees had indicated that they were keen to start the fair pay process. It's quite a wide-ranging application. It covers all workers in accommodation, such as motels, hotels. It also covers your workers in cafes, restaurants, and takeaways, but not catering, which is already covered by other legislation at this stage, as well as workers in casinos and those who work with motion pictures. So it's quite a broad range of workers that will be covered by that, and those are the industries that it covers. And then in terms of the occupations, it includes your bog standard hospitality worker, but also you've got to consider receptionists that work in those businesses. And then it is interesting to see that there have been 2 applications for interurban, rural and urban bus transport. They have both been submitted last month, January. One of them was submitted by the First Union Incorporated, and one of them was by the Amalgamated Workers Union. So we've already got 2 different unions putting in their application. The first one was based on the fact that 1,000 workers had indicated they wanted to start that process through their union, and the second one was based on there being 10% of the workers in that field indicating to the union that they wanted to start the process. So already a couple of differentiations with that, and it's possible that those would be amalgamated at some point. A bit of an overview on what the fair pay agreements cover. So the things that need to be included in there are obviously when the agreement will come into force, and the term for it is normally 3 to 5 years, so it will need to specify the date on which the agreement will expire. The coverage of the agreement, so this requires a bit of clarity. The coverage would refer to something called the ANSCO for the occupation, so that's the Australia-New Zealand standard for classification of occupations. And so there'll be a specific code that's referred to in every agreement or in the application to show which workers are going to be covered, and that application will set out what some of the standard types of work are for a person in that field. So, did a bit of a search on what a lawyer's supposed to do, and it had just a list of about 10 different tasks that might include someone who's a lawyer. And then each type of work that's covered in class of covered employee and standard hours. So if it's a hospitality worker, it would set what type of hospitality worker is intended to be covered. It might be that there's more than one, so it might be that you've got chefs as well as your hospitality worker general, and there might be different terms for those 2, but they could be included in the same agreement. And so there'll be differentiation of the class in that instance. In terms of the standard hours, so that is based on what the standard hours would be for that employee, and this becomes relevant when we're looking at the overtime and penalty rate. So the wage information that needs to be covered, so minimum base wage rate, just recently has been announced that minimum wage is going to increase on the 1st of April from $21.20 to $22.70. So that would obviously be the base wage rate for all employees. The fair pay agreements envision setting the minimum wage rate for particular jobs, and so it might be that in the hospitality agreement, the hospitality worker general has a minimum base wage rate of $24, whereas a chef might have $27. So there's a potential there to be able to differentiate within the same agreement. The overtime rate, so that would be where an employee is working more hours than is specified as the standard hours for either a day or for a week. So say the worker says it's 37.5 maximum hours in a week. If they're working in excess of that, then the overtime rate would apply, and it might be that the overtime rate is to be paid at $1 more than the minimum base wage rate. And then the penalty rate, so a penalty rate is to compensate a worker for working on a particular day or a public holiday or just outside their standard hours. So it might be that if an employee is to be working on a public holiday rather than it being the standard time and a half and a day in lieu, it might be that it's 2 times their pay, and that's what's negotiated. Other things that the agreement will need to cover are arrangements for training and development of staff, leave entitlements, governance arrangements that will apply in respect of the agreement itself, and what the process of a variation of the fair pay agreement might look like. So just continuing that little bit of overview, so there's a bit of an explanation around what the overtime rate is. Other things that they need to discuss, the two parties, the employer party and the employee party, in respect of the overall fair pay agreement negotiation, they need to discuss the objectives of the agreement, whether they're going to include any health and safety requirements, whether they'll include any arrangements as to flexible working, and whether they'll include any arrangements relating to redundancy, which is more common, I guess, in those collectively bargained agreements at this stage than individual employment agreements. So it might be that if they do include redundancy, then those would take precedence over those existing terms of redundancy. Just on the point of these particular items, so they're not mandatory to include in the agreement. It might be that the parties agree not to include it, but they need to at least discuss it. And then there is opportunity for there to be 2 different classes of employee, which we've touched on. So it could be an agreement for a whole industry, but it's 2 different types of occupations or more. And you can have differing rates between those. You can also have differing rates between different workers. So there's obviously the starting out and training rates that apply at this stage. Those would also carry over to a fair pay agreement. And then interestingly, you can differ based on the district that the employee works in. So a barista working in the Taranaki district might be receiving a different wage to someone working, say, in the Wellington region. So there's ability in the fair pay agreement for it to differ based on the district, and that's tied to the districts of the various councils. So the process for bargaining, I've included the helpful graph that Employment New Zealand have advertised. It is a little bit convoluted, but it's something that an employer, if they've got concerns, they should refer to themselves. But essentially, there's 2 different ways that the process can start, and it would be a union applying in both instances. But the first one is either based on representation. So a union can apply if they say that they've got 1,000 workers in that particular industry or occupation, or 10%. So just the ones that we've been applied for at the moment, the first 3 were all 1,000 and the last one was 10%. 10% obviously could be higher or lower than the 1,000, just the hospitality one. The number of workers, I believe, latest statistics indicate it's over 170,000 workers in hospitality across New Zealand. So a 10% of that 17,000, so 1,000 significantly lower. And this is one of the issues that we'll come to later on in terms of representation of these agreements. And then when you're providing the information based on representation, you need to include the name, occupation, employer, and the date that the employee agreed to support all information that the employer needs to be able to provide to the union. And then the second way a process can start is where there's public interest in that particular occupation or industry, and it's covered actually by the Fair Pay regulations that sit alongside the Fair Pay Agreement Act. And it might be that they have to be receiving low pay for their work, and there also needs to be a absence of bargaining power, of pay progression, or it needs to be shown that they're not adequately paid for the job. And in terms of low pay, so low pay means that 60% or more of the workers in the particular occupation or industry are close to the minimum wage, or at the minimum wage, and it can't be where there's 30% or more equal to or around that median wage, which latest statistics indicate is about $62,000 per year. But public interest hasn't been relied on for the first few applications, and it will be interesting to see if it ever is a basis for an application. In terms of who is involved with the process of bargaining for these fair pay agreements, it is initiated by a union. So we've seen that there's been 4 initiated by unions at this stage. Further unions may apply to be joined as a bargaining party. So it might be that in the instance of the interurban, rural and urban bus drivers, that the unions simply elect one will be the lead union negotiating party, and the other one would be added, and then both workers would be included in that. The employers will be represented by an eligible employer association. So there's a bit of publicity around, the employers needing to be able to put forward who's going to represent them, and the fact that Business New Zealand has given an indication they're not interested in being involved. The association would need to show it's got at least one member covered by the agreement, so one employer who has a worker in that particular industry or occupation, a constitution that sets out that they're representing those interests, and that it's also democratic, not unreasonable, etc. And if no one steps up on behalf of the employer, there's a default employer party, which if they don't want to act as well, then it will go to the Employment Relations Authority, who may set the terms unilaterally for the fair pay agreement. Timeframes is quite interesting. There's a bit of information available on the timeframes for providing information. So there's 30 days to review any applications, and that's reviewed by the Ministry of Business, Innovation and Employment. The employers would be notified of an application by the initiating union. So the union's role is to find out who of their employee members works for what employers, and tell those employers, as well as other employers that might have workers in those fields. And they'll also need to publish notices, and there's specific papers those need to be advertised in. The employers then have a certain time frame to provide information on the employees. Employees may say they don't want their information provided to the union as well. Once there's a employer party added or selected, I guess, they would be the lead advocate, and then there's a process for how they would work with the advocate on behalf of the unions. In terms of bargaining, there's no real set time frame for that. That flowchart I referred to earlier has some information around what would happen in the event of a dispute and how those are resolved. And then the agreement would need to be vetted to make sure that it's not inconsistent with other existing fair pay agreements, or it falls short of what the existing standards are. Interestingly, so a fair pay agreement would need more than 50% on both sides for it to be adopted as a fair pay agreement. But in the event it doesn't have that vote for on behalf of both parties, it can still be set by the Employment Relations Authority. Each employee gets one vote, whether or not they vote in favour or against, and that would be communicated through the union. And the employer parties, if you have 21 or more employees in that particular occupation or industry, you can receive 1 vote per employee. So if you've got 25 employees that are in that particular industry, you'll get 25 votes. But if you've got 20 or fewer, then it's based on a specific scale that sets out in the Act, and in this instance, so 1 employee in that field equals 2 votes, and 10 employees equals 15.5 votes. So when we're talking about potential issues, that's one of them in terms of determining, one is your employee covered by the agreement itself, and then also whether the smaller businesses have the ability to have more of a proportion, or whether it's the bigger employees that will have a significantly higher number of votes than the smaller employees. So in terms of the issues that we foresee may arise, there's issues around potential overlap of 2 different fair pay agreements. So one might be put in place for a particular industry or occupation, and there might be another one negotiated that overrides that. So potential issue there is excess amount of time and cost spent on something. Determining if covered, so the standard as to whether or not the fair pay agreement would apply to a particular occupation is whether the employee spends 25% or more of their normal job on that particular type of work. So say it covers an agreement that covers baristas, and someone works in a cafe and does a bit of barista work, but also preps food and does a bit of customer service and serving tables. You're going to need to determine what they are. The majority of their work would be in terms of what their coverage rate is, because it might be that one part of their job is compensated higher than the other parts. So it's really important that, one, you have clear job descriptions for employees, but also a good understanding of what that person does on a day-to-day basis. The 50% threshold, so potential issue there is if you don't get the 50% voting in favour, or you do have 50% say voting in favour, that's only 50% of the people that have voted, and it might be that there's employers who, one, may miss the process for voting because they weren't informed or didn't know this was going on, or there might be some that don't vote. So you might have, a representation of, 75% of employers voting, and it might be that it's more than 50% in favour, but it doesn't actually represent the entirety of the industry. And conversely, it could be the same for employees. Obvious issue where there's no employer bargaining party, and the Employment Relations Authority can just set the terms, and the other issue is around the ANSCO definitions, and making sure that some people do more than one thing at work, and what's their actual occupation in respect to that code. The rights and responsibilities of the sorry, we've just got a case example quickly as well. So in terms of the process for the supermarket and grocery store workers, so this is the third application that had been submitted. It's industry based, and it's for general occupation. So what does that mean? I've got down there what the actual industry is and what the workers are. So this particular application deals with groceries or non-specialised food lines, sometimes on an organised self-service basis, excluding specialised food retailing in meat, fish, poultry, fruit and vegetables, and liquor retailing. So that's obviously excludes your butcheries and your super liquors, etc. And the industry includes supermarkets, bulk food retailing, grocery retailing, Asian grocery stores. And then in terms of the workers themselves, it includes that whole list there that I've put, so your shelf fillers and your checkout operators. But it also includes office managers and the people that work in the butchery section of the supermarkets. But interestingly, it does not include the online pickers and online managers, online supervisors. Unsure why those wouldn't be included, but that's something to note. So obviously, supermarkets would employ a range of different people in different roles, and so this would exclude certain employees of theirs, this particular application. So it might be that there's a minimum wage, base wage rate set for a shelf filler, in the supermarket and grocery store industry, and there's a different one for the office manager. So it's a lot going on in this particular application. I can see it would be quite a lot of time to complete the bargaining process in this instance. The rights and responsibilities for the employees and for the employer. So you need to provide information to employees, provide information around opting out of the unions, of the union membership, allowing an employee to attend a paid meeting. So there's a requirement to provide the employee opportunity to attend at least 2 2-hour paid meetings, and then keep unions informed of what's going on with the employees. And obviously, you've got to comply with the terms of the fair pay agreement once it's in place. In terms of the rights of the employer, so you receive the information, you're able to provide feedback during the process to the lead advocate party, and then you've got the right to vote on the fair pay agreement, provided your employees are covered by it. Just quickly on the possible repercussions, because this is probably the most interesting part for most employers out there. So the risks are you can get a penalty if you unduly influence an employee in connection with union membership, if you breach good faith, if you engage an employee as a contractor rather than an employee. So that might be that your practice has been to employ shelf fillers as employees, but because of this fair pay agreement, you decide you'd rather engage them on a contract for services. That's going to land to the employer in a bit of hot water, because that's clearly identified as a breach of and would warrant a penalty. And then those other ones we've just talked about in terms of what your responsibilities are. So the Act prescribes maximum penalties for breaches. If it's a breach of an obligation when the bargaining is ongoing, so if you fail to provide details or you fail to allow employees to attend meetings, then the maximum for an individual is $20,000, and the maximum for in other cases other than an individual would be $40,000. And then once it's in force, so if you fail to provide your employee with, say, the overtime rate, then you could be looking at a penalty of, I believe it was $10,000 for individuals, in other cases $20,000 is the maximum. But obviously there's other potential risks. So if you're breaching minimum wage, or you're breaching minimum base wage rate, or you're breaching the overtime or penalty rate, then it could be that you're facing a claim for unjustified disadvantage, because you've disadvantaged the employee in respect of their employment conditions, or if you're not calculating the holiday entitlements correctly, based on the change in the minimum wage rate or overtime rate, or penalty rate if there applies to the Holidays Act, then the holidays, and it could be an issue for employers moving forward. So there's quite a lot of risk there for employers. So the main thing is keep yourself informed with what's going on. But it does seem that a lot of employers are keen to know, because we have got a lot of questions, and I think at this stage we'll bring back in Tony and Patrick for a bit of question and answer.
That's absolutely brilliant. It sounds very complicated. I'll from a layman's perspective, sounds like there's a lot for employers to think about. Sounds like there's a lot of fish hooks. It sounds like there'll be a lot of need to keep up to date with what's going on, not only for your industry, but with the process and the progress of various applications. So that's something absolutely that I think is necessary. But let's hoe on into the questions, because we've got quite a few already, and I'm sure we'll have some more as we go along. The first question, it's a bit of a general question, but from an employer perspective, is this just about money? Is this just about increasing the salaries for employees? Is this legislation about that or not?
No, it's as Michael had put in his presentation, that will be one of the main drivers, but it's not the only aspect. There's those mandatory terms which the parties have to negotiate like the leave arrangements and things like that. So it is a wee bit more broader than money, but money will always drive these things, but it's not limited to that. So I think that it would be interesting because the Holidays Act, for example, with leave is quite clear on what the minimum leave arrangements are. But you could, for example, potentially see people see the unions say, well, they want employers to contractually, not through some moral or personal intent, but to contractually give more leave for bereavement leave, for example. The Act only provides a minimum of 3, and some employers only give the 3. Other employers are a wee more generous, they're a wee more kind when it comes to bereavement. So you could see things like those elements of leave be changed. Public holidays to public holidays, can't create more of those out of the blue. There is a potential in some industries or even some jobs that they may want to have a higher annual leave. In the public sector, for example, it's not uncommon for public sector organisations to have 5 weeks annual leave in the contract, where in the private sector, it's more likely to be just the minimum of 4. So those are areas which I think we could see some changes come through these discussions.
Cool. So, I mean, a more functional question around that, I guess, would be, if an employer is currently paying, and lots of employers are, they're currently rate within the fair pay agreement. What would be your advice to an employer in that regard, where their employees have initiated and been involved in asking for the fair pay agreement? I mean, I think I kind of know the answer, but I just wanted to get your views on where you see an employer kind of sitting in that regard.
Yeah, I guess in terms of the employer that's exceeding what the fair pay agreement would be, I wouldn't see why they'd have any issues with the process continuing. As Tony's just mentioned, it's not just about pay. So there are things, like your training and development, or if they do include some health and safety requirements that the employer party would be interested in, exploring or understanding, so that they don't, breach that or fall short of that. And it might be that they pay well, but they don't meet those requirements at the moment. So on an individual basis, you'd want to understand how it would affect that employer party. But if you're exceeding it, I guess there's no real requirement for you to be too opposed to it. I would think it's I guess the point of the Act is to try and make sure that there's not those bad employers out there, and bring everyone up onto even footing.
Brilliant. Okay, cool. All right. So, I mean, in New Zealand, we have a lot of businesses of different sizes, but lots in a similar industry or the same industry. Will the fair pay agreements that get completed apply to any business in that industry of any size, or will there be some differences for those different size employers?
No, I think that the size doesn't matter. It comes down to whether the employees fit the coverage. So this is where the codings, which are specified, particularly in the current applications, the unions have tried to be quite specific in using those ad hoc codes to describe the coverage. And where there is no clear code, they're actually required as part of their application process to describe as clearly as possible the type of work which they're trying to cover. So if you're a small business with 1 or 2 employees who fit that description, whether you like it or not, you're going to have to comply with the fair pay agreement.
Right. Okay. Cool.
Interestingly, it could differentiate on district, which is something I only sort of understood myself quite recently. So it would be interesting to see if there's how that actually works in practice when some businesses are quite close to those borders, and whether that's used to attract staff or differentiate, who knows. But
yeah. And we did have a question on that, Michael, that was, so you did talk about those differences in different locations, which I think is positive, because there are differences in, various aspects of jobs in the regions versus big cities. But that also sounds like there's a lot of loopholes and a lot of complications from an employer perspective to because job descriptions, we all know, are quite different across, even in the same job in different places, we all create our different job descriptions, which are likely to be reflective of sometimes our knowledge of creating those things, and sometimes the different jobs that we're asking our people to do. But is there loopholes? Do you think there'll be things that will get worked through over time to address some of those challenges?
Yeah, I think things will become sufficiently clear once an agreement's in place, and once we see, it tested potentially at the Employment Relations Authority. If someone, say they do work in a smaller business where they are required to do a lot of their time as one particular type of an occupation and one particular type of a different. So if it is, someone working in a cafe and they do spend a fair bit of their time as a barista, but they also do some food prep and they do a lot of just general cash handling as a customer service representative. If there's different rates in the fair pay agreement for each of those, I'm not sure how an employer is meant to figure out which one would apply across, other than just adopting the safe processes while the highest one will apply. Or differentiating the roles of what they're sort of trying to differentiate more what the employee actually does on a day-to-day basis. But I don't foresee loopholes as such, more just a lot of area of grey that it would need to be fleshed out, and I suspect it will be.
Yeah, and so maybe this is a question for Tony. Is because we've worked with you in this area on a number of instances. Is there advice for an employer at this point in time that you would give in terms of, job descriptions, employment agreements, to set yourself up for this potential of a fair pay agreement? And what would be your suggestions in that regard?
Well, I would strongly recommend to all employers, regardless of their size, to be reviewing their job descriptions. It should be something which you do on a reasonably regular basis. Definitely, if you've had someone leave, you should always review the job. But I agree with what Michael's saying. With the threshold for which pay rate you're covered by being set at 25%, that's possible for a person to have 4 25s make 100, and it will create some grey areas. So the best way to avoid or have clarity around that is having a clear job description and an honest one. Don't create a job description which on paper is set to try and avoid being in the situation. Be an honest job description which accurately and fairly reflects the job, and then that'll actually hopefully make it a lot clearer for both parties as to what the role should be paid at under a fair pay agreement.
Okay, cool.
And it's easier said than done, of course, but I think that's the right thing to do.
All right, that's fantastic. And there's great experts like yourselves that can help employers with that sort of thing. So, yeah. So look, moving on now to a couple of questions about the 4 applications that are in process, and I'm sure there will be others over time. Could you, Michael, you've kind of touched on some of the process, but could you give us a bit more detail on, how these applications will be treated, how long it will take, and probably more so, when should an employer that actually isn't party to those requests already, when should they take note of, of the process and start to, get a bit more involved, or aware of the, what's coming at them?
Yeah, so in terms of, we'll take, for example, the hospitality one. So if you're an employer who is clearly part of the hospitality industry, and you aren't aware that this has been filed at this stage, you should be getting notified by the union if you've got people that employees that are clearly part of that union at the moment, or the union should be looking to find out who all the employers are and posting, obviously, in the newspapers that they're required to, that these fair pay agreements have been applied for. In terms of the timeframes, it's really hard to put a fixed time frame in place for how long it would take. But the 4 have been received. The next stage is informing employers that they've been received, and then the employers would need to pass on information to their employees, receive that and provide it back. And I think it was about 15 to 20 working days for each of those different stages. So you're talking a couple of months at that stage for that, and then it's appointing the employer party, and it might be that no one wants to step up on behalf of the employers and be the representative, and that's 3 months might go by and that doesn't happen, and then it falls to a default party, and say that default party was Business New Zealand and they've indicated they don't want to, then it's another month, and then it can go to the Employment Relations Authority. So we're already talking 6 or 7 months at this point before a fair pay agreement might be set by the authority. If someone does step up, then it's just a matter of how long it takes to bargain and how long it takes to negotiate, and it might be that it's months, or it could be years, depending on the number of employees it covers. Because if it's really broad and it's meant to cover your ticket sellers at the movie theatre, or it's meant to cover your your chefs as well, because they work in the high-end restaurants, then it's quite a broad range. So I can see it being quite a lot of to and fro and negotiation, and then you add in the different districts, and who knows, it could be a very long time, and a lot of inputting into Excel spreadsheets for some people. So
sounds like a whole industry in itself.
Yeah.
Anything there to add, Tony, in terms of?
I think a year minimum, I reckon. I understand this legislation is based on what they have over in Australia already. I haven't looked too closely at it, but I do understand it can take up to about a year to get these things through over in Australia. So I don't expect us, particularly on the first round, to get them through any quicker than what they would get them through in Australia. As Michael said, 6 months to get going. That's a significant amount of time. And then the notification requirements, not only on the union, but once the union's notified the employer, then the employer's also then got to reach out and say, well, who else do we deal with in terms of unions? And they're quite onerous. And I think that's, the timeframes which are given, they might sound, 15 days for this and 20 days for that. If you've got a large workforce and you've got to chase down, a couple of hundred people for their forms, because each person's got to complete a form to say whether they're happy or not happy for their information to be passed on to the union, that's not going to happen overnight. So as soon as, whilst the Act says you technically don't have to worry about going down that process until the application's been approved by MB, maybe a wise employer shouldn't necessarily wait for the approval. They should work on the basis that it probably will be approved. So start at least getting your forms ready to go to your people, and even start talking to your people about how do you want to play in this. Start filling out your forms now. Don't wait.
Right. And we did have a question come in around, I'm a small business. I've got a couple of employees. My employees aren't a member of a union. How will I get informed if I am in that position? And actually, do I have to comply at that point? Because neither of my employees are in the union. They're not being kind of party to asking for this, or what's the status on that sort of size of employer?
Yeah, that's an interesting one, because and that comes down to the problems with the notifications, because a union, if they don't have members, isn't going to know that mum and dad who've got a small business and hiring a couple of people, they're not necessarily going to know they exist, and so they're not going to be notified. And unless the mum and dad owner are looking at the MB website at the dashboard, or have someone who's an advisor or a lawyer or an accountant who's onto it and says, hey, you need to be aware of this, they could get left behind. And the other ones who potentially could get a knock on the door for failing to comply with an FPA, which they didn't even realise existed. Though having said that, realistically speaking, because these are new, I suspect that whenever the first one goes through, there'll probably be enough fanfare in the news and on the telly about it, because the unions will want to make a good news story out of it. But that doesn't mean that everyone necessarily is still going to see the information. But it is a problem, I think. And yeah, how it plays out is $64,000 question, really.
Yeah, hopefully there'll be some pragmatic kind of approaches at that point in time.
Hopefully, yes.
We shall see. Look, we're going to move on now to what your views are on how an employer should be, starting to engage with their employees, and what some of the steps are in what an employer should be doing in engagement once they find out that their industry is party to one of these fair pay applications?
Yeah, so I guess the first step is, if you are notified of it, there are obligations you need to comply with in terms of providing information to your employees. But employers themselves, I guess, Tony mentioned this before, review your position descriptions to make sure that people are covered by it. And if you've got issues around, position descriptions changing for employees that haven't been updated, maybe getting onto those now, and getting an understanding of, how best to define them so that they do fit neatly within that particular industry or occupation. And then in terms of if a fair payment agreement does get adopted, it does take precedence over the existing arrangement. So the steps they need to take at that point are, you don't need to get them to sign a new agreement or anything, because it automatically applies, but it might be that an employer would want to prepare some form of one-pager document which sets out what the new terms are, and making sure that they've got their payroll and everything lined up to take effect from the date that agreement does. And just taking advice, I guess, if you do have any issues around when it's to take effect, or how to communicate it to the employees, and obviously if there's new employees starting after that date, making sure that your new agreements for them have got covered. Obviously, minimum wage would be obvious, but there's the training and development parts of it as well, making sure those are covered. So just keeping themselves informed is the best advice that I can give, is keep up to date with the updates.
Good. So that kind of communication sounds like it's a key part of working with your employees, but also some keeping yourself informed about what's going on, either through MB or through organisations like yourselves or the Chamber of Commerce, who will be able to provide updates as well. So that's cool. So this might be a fairly straightforward question, but it's something that's come up from one of our businesses. Is there's currently two applications for fair pay agreements in the kind of bus driver area, I think, or transurban kind of area or interurban, I think you described it as. Which one would apply to me if I'm in that sector, or what will happen in that regard? What's your thoughts in how I navigate that?
I think Michael covered that in his presentation, because the only difference between them is one of them adds in cleaners and refuelers, and the first one covers basically your drivers, for one of simplicity. Michael's correct. I believe MB's not going to set two parties off to have a fair pay agreement about both things. They'll be drawn together, so there will only be one fair pay agreement, and it'll cover the broader spectrum, because the Act provides that as well. Because if there is a fair pay agreement already in place, that's part of the consideration which MB goes through when they're looking at the application to say, is this one actually necessary? Is it going to be any different? Is it going to add, or is it the same? So when there's two come in like this, it probably increases the likelihood for it to be approved by MB, but it'll become one.
Right. Okay. Cool. So there won't be that kind of issue of navigating your way through two, even though they have slightly different. Cool. Fantastic.
Probably from just to pick up on that, where it is different. If you've got a collective agreement about to be negotiated or under negotiations, the fair pay agreement doesn't stop the collective agreement bargaining. So that's two separate regimes. So you can still have a collective bargaining happening at the same time as a fair pay agreement. So if you're in the hospitality or in these transport areas, the fact that there's a fair pay agreement being lodged and you're about to enter into your negotiations because your contract's about to expire, you don't stop. You continue as if there is no fair pay agreement, but you'll need to be cognizant of what's going on with the fair pay agreement. So that's one of the complications and issues for employers, I think, from these things.
And I think, as Michael said earlier, what I heard was that the fair pay agreement may supersede a collective agreement. Right. Okay. Yeah. So these two things could be going on at the same time potentially. Yes. Yeah. Right. Okay. Cool. Do you have a question from an employer was, will this apply to me and my industry? I'm not sure which industry in, but what is it expected that it will cover every industry in the long run if this kind of takes off?
I think it'll be the ones with the stronger unions at the start that are keen to get, and they don't have good collective bargaining agreements in place at this stage. They'll be keen to really progress these. The public sector itself, so there's a different bit of a different regime for the employer association there. So if it's in those industries, I think there's a public service commissioner as the lead employer bargaining party in respect of those agreements if they go ahead. So we might see that there's a few in that area. I think the police and parliamentary service and maybe defence also and Te Whatu Ora all have their own. They are the ones that will negotiate on behalf of themselves in the event that those go ahead. So the fact that they've been specifically identified might mean that they're more likely to happen. It might be that there's one in those industries, or it might be that, given there's collective bargaining agreements in some of those areas at the moment, they're less likely. But I would expect, the ones that have got strong collective bargaining agreements in place at the moment, or strong unions, those will be the ones that we see taking off.
Cool. So that's about all of the questions we've had. I mean, you really comprehensively, Michael, covered some of the most of the points in your presentation. So that's been really helpful. And Tony, your input over those questions has been really helpful. Is there any last advice before we finish up that you would, what's the one or two things that you would, particularly like an employer to think about before we finish here? Tony, maybe we'll start with you.
Yeah, I'll go back to what I said earlier on about job descriptions. Make sure that your job descriptions are up to date. Make sure you've got good records, because you're required to anyway, on your employees. And if you are in the hospitality area, if you're in the transport area, actually it doesn't really matter which sector you're in. Make sure you've got good up-to-date information on your employees, because if you get hit by one of these fair pay agreements, you are going to have to provide information on your employees to the union party and also to the employer party, because they need to know who they're covering. So make sure your records are up to date. Make sure you've got good contact information with your employees so that you can reach out to them really quickly to find out whether, particularly if they're non-unionised. If they're unionised, the union should already have their information. But if they're non-unionised, make sure you can get to them really quickly to find out whether they're happy to have their information passed on, or whether they wish to opt out of the information being passed on. And that's one point which probably we didn't cover all that much. Opting out of your information being passed on doesn't mean you don't get to vote. You can still get to vote because you still get covered by these fair pay agreements.
Presumably, though, if you give your information over, it's subject to the Privacy Act and can only be used for the purposes for which it was collected. So a union, for example, couldn't then solicit you to be part of the union, as using that information for that purpose, presumably. Yeah. Michael, is there any last points you'd like to make?
Look, Tony's made some excellent points here about record keeping and keeping yourself informed, and I think that is the main thing: is do keep up to date with information. As we've discussed, there's a lot to be seen with these. A lot of changes on the horizon, and a lot more will become clear over time around how these are going to work. So I think keep yourself informed, and at this stage, don't be too afraid of what's going to happen, because it'll become clearer, and it's ultimately, hopefully, it will be for everyone's benefit in the long run if it does continue.
So keeping up to date with this information is a pretty key point, really, at the end of the day. Yeah. Fantastic. Okay, look, thank you so much, Michael and Tony. It's great to have Gibson Sheat and McKone Consultancy as partners of the Chamber of Commerce, and it's always fantastic to be able to tap into your knowledge and expertise that our members can learn from and hopefully benefit from in keeping up to date with these really important subjects, particularly around employment law and some of the things that are coming at them in terms of fair pay agreements. So really appreciate your time. Your expertise is always valuable. So thank you very much indeed. The Chamber of Commerce, really in closing, will continue to bring you a number of information videos over time. And we'll continue to bring face-to-face events. So if you need further assistance, please don't hesitate to contact me or one of the Chamber team. We're always here to help. So thank you, and hope you enjoyed this live stream from the Hutt Valley Chamber of Commerce. Thank you.